you cannot do an inspection.
What are the various statutes or laws that help protect these rights of a homeowner?
There are two options that homeowners can do at this juncture.
What steps can the homeowner take to ensure that their rights are preserved? Hi Sneha.
Hi.
Welcome back.
Thank you.
We've been talking a lot about resident welfare associations. I'd like to now change a bit and talk about individual homeowners.
Ever wondered how to build a house that lasts generations to come? Or why that crack on an apartment wall just won't go away? Why is there that pesky seepage in that corner? Welcome to the 𝗵𝗲𝗃𝗀𝗀𝗃 podcast.
We've had situations, as you know, we at 𝗵𝗲𝗃𝗀𝗀𝗃 provide a service called home inspection. You being a lawyer, I thought you'd be able to throw some light on this particular situation and how an individual homeowner can get some idea as to what they need to do when they face the problem. The situation is this: we as auditors, third-party quality auditors, get individual customers who are homeowners and ask us to provide home inspection. The juncture at which this happens is when the builder says, your apartment is ready, please come and do your final check. Because the homeowner is not technical, they reach out to us and say, why don't you help us do this audit? And when we end up reaching the society or end up reading the project, in certain cases, certain projects of certain builders, they prevent the homeowner from getting a home inspection. And they are worried because at the end of the day, they end up taking up a property without understanding the status of that particular property. So what is it that homeowner can do to get what is truly theirs?
Right. So as such, there is no bar in law to get an inspection done. I believe
what do you
that
mean by no bar in law?
there is no law which says that, look, when you're not in possession, you cannot do an inspection.
Okay.
What I mean by that is, if I have an option as a home buyer to inspect the property before executing a sale deed, either I do that myself or I am permitted to get a representative on my behalf to do that.
When you say executing a sale deed, I think I'm just asking these questions so that there is clarity for various homeowners. People say they are forcing us to take possession.
Right.
So when they say forcing us to take possession or saying, no, you can only do this after taking possession, is that what you're referring to as?
So what the sale deed does is, the sale deed effectively is a document that is putting you in possession.
Okay.
That's when you become an owner.
Correct.
Until that, you don't have possession to the property, which means you can't freely enter, do what you want. None of that is permissible, because until you sign the sale deed and you're put in possession, the builder or the landowner, whoever has a share in that apartment, continues to be the owner. So therefore, sale deed is a document that determines ownership and who's in possession. So until you sign that document, you are not in possession. However, for you to sign that document, you have a right. You have a right to go see whether the construction is put up in the manner that was promised, what was mentioned, etc. And a lot of homeowners, or I'd like to believe most of them, don't have the technical knowledge to conduct this kind of inspection. So when the builder asks them to come and do the inspection, what it essentially means is you can come and do it yourself, or you can authorize somebody on your behalf to come and do it. So if the homeowner is authorizing, let's say 𝗵𝗲𝗃𝗀𝗀𝗃𝗀𝗃, to conduct this home inspection, then there is an authorization letter saying that I'm inspecting the property on behalf of Mr. So-and-so. And then you are allowed to conduct, a technical audit.
So is an authorization letter mandatory, or does it make things easier and more official?
See, mandatory or not is something that the builder has to decide. But the right way of doing it it's better that you have an authorization letter, because otherwise, under what capacity are you going to the property, which doesn't even at this particular point belong to the owner. So therefore, the way I would look at it is to have an authorization letter or a letter of authority saying that they are coming and inspecting on my behalf. There's nothing wrong in that. Ideally, in such a scenario, the builder should permit.
Okay. So the authorization letter should just say, I, so-and-so, homeowner of so-and-so apartment in so-and-so project is authorizing 𝗵𝗲𝗃 as a third-party quality audit firm to perform the audit on my behalf because they are technically capable, signed, that's it.
You can say something so
Yeah.
in detail, or you can even say that I'm authorizing so-and-so to inspect on my behalf. You can even keep it that simple.
Simple, okay. It need not be as complex.
Yes.
What happens if after the authorization letter is given, we end up at site, but the representative at that project still doesn't allow our engineers to perform this audit on behalf of the homeowner?
Technically,
What steps can the homeowner take to ensure that their rights are preserved?
see, technically, a builder or anybody from their team shouldn't prevent. But in the scenario, or in the scenario that you're mentioning where they're preventing you from even entering the property, ideally the homeowner should record, document what happens on an email,
Okay.
saying that so-and-so came on my behalf and they were not allowed to inspect. We don't know the reasons, which means that I'm not able to inspect my property before taking over possession. So that kind of communication is very, very important. Of course, at that moment, you will pick up the phone, you will talk to somebody, you will try to, get them to go inside and inspect. But despite all of that, if they don't permit you to inspect, then as a lawyer, I believe that it's always important that you document the communication, and the best way to do it is over email. Don't rely too much on messages, WhatsApp, etc. Ideally, even if you've done all of that through phone calls and WhatsApp, etc., always post facto go and put an email and record what happened.
Okay. For the purposes of this discussion or argument's sake, even after sending a letter, or even if there's an authorization letter and then that is sent via email to the CRM head or the project head or whoever, and they continue to say no, and you have recorded saying that even though we have come and we've authorized them and you're not preventing us, and they continue to hold their stand and say no, we will not allow, then what steps can the homeowner take so that they can get what is truly theirs?
See, essentially that means they're not allowing the homeowner to inspect. That's what this means. So there are two options that homeowners can do at this junction. One is they can say, all right, if that is the case, I will take delivery of my property, which is I will execute a sale deed and take possession of my flat. However, please note that the inspection, or that I am taking this possession in protest, or record saying that I'm taking this in possession even though I've not inspected the property. So once I take possession and the flat belongs to me, I will go ahead and conduct an inspection and let you know if there are any problems.
What are the various statutes or laws that help protect these rights of a homeowner?
RERA, if it's a RERA registered project, today we have RERA which says that you have defect liability period.
Okay.
So from the time you take possession, it's 5 years, you have defect liability. So it's important that as soon as you sign the sale deed, if pre-sale deed, you're not allowed to conduct the inspection. Post-sale deed, I think the very first thing to do before you start interiors would ideally be to finish the home inspection, start building the communication with the developer if there are any defects, saying that these are the defects and you have to rectify this. Because a lot of times what happens is that, let's say you move quickly with interiors and then you do an inspection, and if there are actually problems, the builder may also say that, look, you've already made changes, I can't do much at this point. So I think it's very important to be cautious to first finish inspection and write to the builder, establish communication. If the builder is not cooperating in doing it, then you rectify, finish all the civil work, pass on the bill to the builder and say, please pay this. If they don't, then of course you can go to court and make the claim, saying that this, is...
Got it. So,
defects.
but it's a long process. But the easier one, as you said, is, I'm going to paraphrase, say that we take, as a homeowner, you take possession. That means you execute the sale deed. After that, you have a communication, or during that, you have a clear communication with the builder's representative, saying that because you prevented me, I am taking possession. However, this does not mean that I am waiving my right. I will get the home audit or home inspection performed by a home inspection firm, And this is going to be a visual report that will tell you these are the various problems. And once you get that rectified, then I will move in. So that works.
You can do that.
You can
That
work.
works. I mean, there's another way, of course, to do it, to say that I will not take possession unless you allow me to
Yes.
complete it. That's, of course, the other way. But what I also think is that a lot of people may not be in that position to do that, because they probably need the house.
Correct.
They need to move in. There are, financial issues that could come in. So, one way, of course, is to say, I'll take possession, then sort it out. The other way of doing it is to say, I'll wait it out no matter what. I'll ensure the builder does it and then move in, because that could take a long time.
Correct. Okay, now let's take a deep, dark end scenario where I have moved in, I have performed the home inspection, and I've given this report to the projects team, and they refuse to move on it. Then what?
So ideally, in a scenario like that, you should spend money and rectify the defects yourself, but document everything. And once you have that, you send a letter or notice to the developer or the builder to say that, look, these were the defects that was identified, which was already informed to you. Because you didn't come forward and rectify this, I have spent my money rectifying this. This comes under your obligation. So therefore, now I request you to make this payment, monetary payment to me.
Not many people are financially able to do this, because a lot of people in India, at least, buy a home once in their lifetime. They probably buy it on mortgage or buy it on a loan. And if there are 200, 300, 400 problems that are in a house that needs to be repaired, it's going to cost them lakhs of rupees. Can they hold ground and say, no, you have to do this before I move in?
See, you can, but then that will also delay your moving in. So there's a choice you have to make. You can say, I will not move in for the next 2 years.
So it's the cost benefit analysis of how much.
Absolutely.
So it's a rent versus mortgage that you're paying,
Yes.
versus an added thing.
If it's a serious structural defect because of which you can't even move in, then no matter the money, you may want to adjust and fulfill that requirement.
Got it.
But if you can wait it out, then of course you can also, ensure that the builder comes and does it, either through legal manner, or if the builder is, you're still in talking terms with the builder and you want to get it done, whatever manner suits you, you can wait it out and do it as well.
Got it.
But whatever it is, what is absolutely important and necessary is that everything is documented.
Got it. And everything is documented via email?
Email.
Or does it have to be via the old school registered
No,
post?
emails work very well.
Emails work very well. And it could be your personal email ID.
Yes.
Anything
Yes.
works. Fantastic. Anything else that you'd like to share, so that, because people also talk about builders saying, look, there is defect liability period, there is RERA that mandates 5 years. Why do you want to get a home inspection done? What is it there for you? Why are you spending money? We will take care of it. What we say as 𝗵𝗲 is that we understand that it's all there, but at the end of the day, don't you want to know what you need to get repaired? Because if you move in and there is problems, you will spend a lot more time trying to get all of those repaired in different point solutions, rather than getting that done in one full sweep. What do you think about it?
I mean,
What
I
is your
completely
suggestion?
agree. I think it's very important that you know what defects are there in the property that you're moving in, and you're not caught by surprise once you move in. And also, I think giving the builder a snag list and saying that, look, I need you to comply all of this, makes it easier for both the builder and you, because you know what needs to be done, and the builder also knows what needs to go in terms of work. So I feel like it's more organized. The process is also very clear. So I would definitely encourage people to follow this process and take advantage of it.
What if the builder comes and says, okay, you've given me this snag list, I will only attend to things that are on the snag list and once. I will not do it again or ever again. Is that legal? Can the builder do that?
So of course he addresses the snag list. And once the snag list is rectified, you can look at that snag list again, right? Suppose there's leakage and he says, I'll fix the leakage, but I will only fix it once. Once he fixes the leakage, he should have done a proper job. So there's a further inspection that's required of what is already, repaired as well. So he can't say that, so which is why I said following a chain of communication, recording each thing becomes very important, because you will have to show that this is not a new defect that has come up. This is a defect that existed, which you have worked on, and it's still not satisfactory. That's something you should be able to prove. And the reason it's always better to do all of this before you move in is because the builder then can't say that, no, I don't know when this defect arose, definitely not when I handed over the property. It's come subsequent to you using the property for 6 months, puts you in trouble, because how do you prove that?
That's why our reports have a timestamp on it. So that makes sense. I understand that. That's good. Very good. Anything from your experiences you'd like to share with the customers?
I think one thing that I would like to stress again is communication is really the key. How you document all of this, how you put them on record is very, very important. Do that very diligently, because if you don't have that, you may have a case. But if you don't have anything on record to show what has gone wrong, then you're really at a loss. So communication is really the key.
Thank you. Thank you very much.
Thank you so much.
Please remember, if you have anything that you need to share, either with the builder or the builder's representative, please send an email. Make sure that the email has got all the details so that they will know that it is not a new thing or it is repeating. It's for your own good. Thank you. Thank you again.
Thank you so
very
much.
much.